I would like Dr. Jena to start his topic, please. Thank you.
Thank you, sir. Respected Jay, sir, Director, sir, all the colleagues sitting here and fellow participants in the webinar. I heartily congratulate Department of Justice for this very innovative scheme of DISA, Access to Justice, and I really feel privileged that I have been part of this program and scheme, wherein I can also share my thoughts about the newly implemented labor codes. The ministry is very regularly engaging with the various stakeholders so that the essence of labor code, the philosophy behind it, the idea behind it is down below percolated. So we are really thankful, sir. Thank you for this opportunity. Can I please show the slides? I'll just run through a few slides wherein I will discuss in brief about the rationale behind the labor codes, the various benefits for the employers, for the employees, and how the ministry is, implementing the labor codes across the country. Next. So, as was mentioned by the Director Sir in the beginning, there are around 44 central acts in the country with various provisions which were, with the definitions varying in varying acts. Like, for example, the definition of wage was different in 14 different acts. Similarly, authorities were defined differently. So it was very difficult to actually comply to those provisions under the various 44 central acts. What we did is that 29 of them were subsumed and made into 4 labor codes. 12 acts got repealed because they were very old and not relevant to the present context. 3 acts have been retained which are of a very specific nature. So that have not been subsumed with the 4 labor codes. These codes were enacted by the Parliament in 2019 and 20. Wage code was in 2019, and the rest 3 codes, Code on Social Security, Industrial Relations Code, and the Code on Occupational Safety, Health and Working Conditions Code, that was also enacted in 2020. But these codes got implemented on 21st November. There was a lot of stakeholder consultations going on. And finally, November last year, these codes were implemented. And subsequently, on 30th December, the draft rules under these codes were again republished, because those were previously pre-published for stakeholder consultations. It were again, since a lot of time had elapsed, it was again pre-published on 30th December, and finally on 8th of this month these rules were finalized and notified. Next. So as I was mentioning, there are multiple labor laws and having multiple authorities, different definitions across the labor acts, which was very difficult for compliance, and some of the labor acts were actually pertaining to pre-independence period, and most of them were actually were enacted during the early independence period. That means with 60-70 years of old acts, we are running the country, and we were emerging Viksit Bharat with 19th century, 20th century acts. So that was the reason why a big scale reform, labor reform in the country was actually envisioned. Subsequently, Second National Commission on Labor way back in 2004 also recommended to codify the labor acts. And subsequently, different stakeholders from industry, from employers, from labor unions, these requests were also pouring in to amend or to enact the new labor acts, taking into consideration the requirement of the country in the present context. So that is how these 4 labor codes actually were enacted. Next. These are the overviews. 2019 Code on Wages were enacted that consolidated 4 acts This code has the provision of uniform definition of wages, universal minimum wages, and timely payment of wages. Wages related acts have been subsumed here and accordingly updated. Similarly, the Code on Industrial Relations consolidates 3 acts. This simplifies the dispute resolution. This promotes industrial harmony and improves business environment. Something about this my colleague Govindramji will be discussing in detail. And the third is the OSH or OSH code or OSH Working Conditions Code 2020 that consolidates the maximum 13 number of acts which is related to the welfare and working conditions of the workers. The fourth is Social Security Code 2020 that consolidates 9 acts, and this is related to the social security provisions of the workers. And this code has the vision of providing universal social security coverage to all types of workers, workers in the organized sector, workers in the unorganized sector, as well as the new types of workforce that is emerging in the country, the gig and platform workers. Next. If you look at this slide, this broadly discusses about the scale of reform undertaken through these codes. As far as sections are concerned, this number of sections in the codes in comparison to the previous acts have been reduced by 61%. Rules reduced by 75%, forms by 60%, and registers by 90%, which is quite relevant for the industries, for employers, as far as the age of doing business is concerned. Similarly, returns, registration, and license, these were multiple as per the previous acts, which have been made single and made digitized. There are 3 important provisions in the present context which have been introduced in the code, that is decriminalization, compounding of offences, and improvement notice. Now, under the previous act, there are 87 such provisions which attracted imprisonment. In fact, there are very small or minimal nature of non-compliance that also attracted imprisonment. For example, consider this room as a factory, and if the factory has not been whitewashed properly, that also was in the rules of some of the states, that also was attracting imprisonment. So what has been done in the courts is the entire penalty or imprisonment provisions have been rationalized. Somewhere even the financial penalty has been considerably increased as a deterrence for second or repeat offense. At the same time, wherever the offences are very serious or grave, imprisonment provisions have also been given. So it has been rationalized, reduced. So there are only 22 provisions where it attracts imprisonment provisions under the courts, but out of that, 16 are compoundable. So only 6 such provisions are there which cannot, because those are related to very serious offences like life and death of the workers, social security related matters. Those cannot be compounded. So that is one kind of rationalized reform, I must say, in the labor courts. Similarly, compounding of offences was not there. That has been provided. Compounding officer will be notified by the appropriate government, and the affected party can approach the compounding officer for compounding of the offences for their non-compliance. Similarly, improvement notice. Previously, that was not there. If there is a non-compliance noticed in an establishment, either penalty or imprisonment directly was ensured. But now the establishments will be given improvement notice. We are giving you this much time, a month or whatever, and you can comply to the labor laws. So that improvement notice will be given to the employer, which substantially gives scope to the employers or any other stakeholders to comply to the provision, so that imprisonment or fine or any kind of penalty is avoided. So these are the 3 very forward-looking provisions in the labor codes which have been introduced. Next, sorry. If I go to the key features of the labor codes, as I said in the beginning, there are uniform definitions across the codes. The definition of wage, employee, workers have been rationalized. It is uniform now. Technology will be leveraged. We are making lots of forms and registers online so that it gives freedom to the establishments, to the law enforcement agencies also to function. Then one of the most important feature of the labor codes is the transparency in enforcement. You must have heard about that colloquial term, Inspector Raj. That was also happening in the labor sector. Now the inspector will be called as inspector cum facilitators, wherein they will facilitate the employers and create awareness among the workers about their rights and duties, and facilitate the inspectors for the industries or factories or establishments to comply with the labor laws. Not for that also, not just in the law we have made these changes, but internally we are also initiating a lot of capacity building programs so that the inspector actually become inspector cum facilitator, not just in the rule book. And second, the inspection system entirely also being actually digitized. It will become web-based and it will be randomized. There will be risk matrix based on the risk profile of the organizations or establishments, and system will decide where to to conduct the inspection. So there are two, very, I must say, specialized provisions in the labor codes which will ensure transparency in the enforcement mechanism is concerned. There are similarly very progressive provisions in the labor codes which will ensure higher female labor force participation. Previously, under the Factories Act and under certain acts, there are certain acts, certain type of work where women labor or women workers were not permitted to work. Similarly, at night also they were not permitted to work. Now, under the codes, women are allowed to work in all types of work, all types of establishment, also during night time, subject to their consent, and the employers have to ensure their safety and transport. This is a progressive legislation considering the present day India. Similarly, crèche facilities will be provided in the establishment having 50 or more employees. Now here the employees word has been made gender neutral. It includes men, women and transgender. Previously it was women employee, which means that it was difficult for an establishment to actually create crèche facilities because 50 employee एक साथ कहीं हो सकता है कि ना भी हो. But with such provision in the labor code, in case there is an establishment of 50 employees and only one woman worker is there, still the crèche facility has to be provided. And this includes ministries also, government establishment also. So there are adequate and proportionate representation of women in boards. There are national boards where various stakeholders are the members. In such boards, the women workers have to have their adequate and proportional representation. This is also very progressive legislation as far as labor codes are concerned. Next. Continuing with the provisions, if I go through the promoting labor welfare provisions in the labor codes, as I said, universalization of wage security. Previously, the minimum wages were fixed by the central government in very few selected sectors. Now, the minimum wages have to be universal. It has to be applicable to all the sectors, that means it has been given a statutory right. So all the sectors, regardless of the type of employment, the minimum wages have to be fixed by the appropriate government. I am using the phrase appropriate government because Director Sir was mentioning in the beginning, labor is a concurrent subject. So there are spheres of operation. There are central sphere and there are state sphere. So depending on the sphere of operation, the appropriate government or the concerned government will define the minimum wage for that sector. There is also timely payment of wages. Payment has to be made in time. The time has been fixed, which is also a progressive legislation, and the introduction of national floor wage. Now what happens is that state government defines the minimum wage for the state sphere, central government in the selected central sphere. What is happening is that there is a large scale regional difference in the minimum wages across the country. So that has been taken into consideration, and in the labor codes, central government will define a national floor wage. It will not be a single wage. It will obviously based on the regions. It will vary from region to region, but the magnitude of difference that was there in the minimum wages across the country will substantially be reduced. So this is also another progressive legislation under the labor codes. Similarly, universalization of social security. The social security code envisions to provide social security to all types of workers, including the gig and platform workers. For that, there is a social security fund, which will be actually funding the social security schemes that has to be run for the unorganized sector and gig and platform workers. Then there is a provision of a portability of benefits for the interstate migrant workers. That is a section of workforce which is most neglected. That has been ensured under the courts. Next. Universalization of safety standards. Again, safety standards, central government was defining only for 7 sectors. Now it has been made universal. This safety standard will be centrally or will be defined by the central government, which all the states have to follow. So that it will be a universal safety standards across the sectors and across the country. Formalization of labor, wherein the employers are expected to issue mandatory appointment letters. This will lead, because the appointment letters will define what kind of labor he is, what is the duration of his engagement, what kind of minimum wage or whatever his wage he would be getting. All these would be given in the appointment letter, which will lead to formalization. Because sir was mentioning in the beginning, we are a country having one of the largest working population in the unorganized sector. This will lead to formalization of the labor force. Fixed term employment provision have been given in the IR code, also in the social security code. This will reduce contractualization. There are provisions for skill development. If the workers are retrenched, then there will be reskilling fund which the employers have to fund for. That would be around 15 days wage of last run, which will be credited to the account of the retrenched workers, which will be used for reskilling of that particular actor to increase his employability. Next. For the wage code, again, minimum wages, as I said, has been mandated. National floor wages has been mandated. The payment has to be made based on the type of engagement, on daily basis or weekly basis or fortnightly basis or monthly basis. The particular timeline has been given in the courts. So the establishment or the employers have to ensure that there is timely payment of wages. Uniform wage definition, as I said, if the allowances, previously this is one of the progressive, and for this also we faced a lot of resistance. Previously what happens, if a worker gets 20,000, for example, minimum wage is defined as 10,000, Baki rest 10,000 was defined as different allowances. What happens is that the ESI and EPF components is contributed on the basis of minimum wages. So you get 20,000, but you get the ESI EPF component or contribution on half of it. So there is compression of wage as such. So that is why a clear definition has been given in the wage code. If the quantum of allowances exceeds 50% of the actual wage, then that additional component will be added back to the basic wage. So this gives a scope for the worker that his ESI EPF component is deducted and deducted in right amount. So there is also a provision for overtime compensation, which is paid twice the normal wage. This is also very progressive, as far as the welfare of the workers is concerned. Next. Wage slip has to be mandatorily issued, which will gives that gives the worker a proof that this is my actual wage and what I got. So this is a feature in the wage code. Settlement of dues, if the worker is retrenched or he resigns, then within 2 days his basic wage related dues have to be cleared. The provision of bonus is there. Actual wage ceiling for the bonus has to be notified by the central government, but as far as the repealed act is concerned, it was 21,000 or below, and the bonus amount was either 7,000 or the minimum wages, which was higher. So the bonus provisions are there in the wage code and in the social security code and wage code as well. Next. For the women, as I said, there should not be any discrimination on the basis of gender in payment of wage. If similar work is being done by male and female, then similar payment or similar wage payment has to be made. No discrimination on the basis of sex in recruitment. There should not be any discrimination. Then 1/3 members in central or state advisory boards, as I was mentioning, their voice in wage fixation. If minimum wage is fixed by the wage board, which is an advisory board, and proportional representation of women would be there. That means in the policy decisions of the country, women will have direct say. This is one of the very progressive legislation done in the labor codes. Similarly, advisory boards and other boards, they have a proportional representations. Next. Fixed term employment, this was a lot of there was a lot of demand from various stakeholders to introduce this. This has been made as part of statute now. Gratuity for fixed term employment will be given if even he completes only 1 year. In case of permanent employees, it is 5 years. So that is also one of the labor friendly provision in the IR code. Retrenchment of workers with at least 1 year of continuous service, they have these facilities, 1 month's notice before termination and 1 month's wages in place of notice. These provisions are given in the IR code. Then reskilling fund, I was mentioning on that, 15 days of wages will be given to the retrenched worker. Next, expansion of definition of worker. Journalists, supervisors getting 18,000 and less, because this 18,000 limit will be subsequently revised by the government, but under the statute it has been brought under the definition of worker. Then digital artists and stunt persons. For the movies, film industries, the Heroes Act, but actually stunt persons are different, which we do not see. Those are very risk prone. They undergo a lot of risks and injuries, and they were not been taken care properly. So that is why they have been brought under the definition of worker and the courts. Then there are grievance redressal committees where the workers can try to resolve in association with the employers, resolve their issues. A timeline have been given, how it will be constituted, how much time it will take to resolve those grievances. Then works committees are there with a certain number of workers in an establishment. Next, for women under the IR code, if the women have completed, the women worker have completed their maternity leave, then if the employer agrees, they can also work from home. That is also facility given. And work from home concept, Honorable Prime Minister very recently mentioned. That is also available in the course, not just for women, but also for other sectors. That facility, remote work facility, all these have been given in the labor course as well. Then there are internal complaint committees like any other establishment. That facility is also there. OSS rules defines about the ICCs and the various provisions under the same. Next. Coming to the Social Security Code, the Employees Provident Fund, ESI scheme, same thing have been actually copied. So I will not go into details. Next. The employees compensation. The most important provisions under this is that if you are commuting house to work and workspace to back to house, during commuting, if the accident occurs, this will also employee compensation will cover that. That was not there previously. That was the progressive provision in the labor codes. Next. Gratuity and provision same almost, what was there in the previous acts. Unorganized workers social security fund will be there. Then social security fund will be there for the gig and platform workers I mentioned. There are defined social security schemes which will be run by the ministries and appropriate government for this type of workers. Next. Gig and platform completed. Next. For women under the Social Security Code, family definition have been revised. Parents-in-law have been made part of family now. Crèche allowances 500 per month for child to be given. Then crèche facility for employees, that word has been made gender neutral. And protection from dismissal during maternity leave. आप उसको dismissal नहीं कर सकते. ये प्रोटेक्शन दिया गया है. Then provision of paid leave for miscarriage 6 weeks, that provision has also been made part of the course. Next. Maternity benefit 26 weeks, same as the previous acts. There will be post delivery 2 nursing breaks, medical bonus of 3,500, or these are progressive legislations. Next. Under the OSH code, again the contract labor to huge contract labor in the establishment, 20 workers, previously it was 20 workers, it has been increased to 50 workers. Then pre-annual health examination. This is also very progressive, very labor welfare provision made as part of the labor codes. Then appointment letters, as I was mentioning about that. Annual leave with wages, national welfare standards, which I said the central government will define the wage standards which the state government will follow. Next, special provision for contract workers. Please note this, the regardless the strength or the strength of the workers in the establishment, wages have to be paid within 7 working days of the next month if they are engaged monthly basis. Previously it was different depending on the strength of the establishment. Then mandatory canteen facilities, shelter, restroom, first aid box depending on the type of establishment, whether it's a factory or different kind of establishment. These facilities have to be provided. Interstate migrant workers, they had to get to and fro journeying allowances, also portability of the benefits. Next. Then to boost the female labor force participation, women are allowed to work in all types of establishment and all types of work. Last 3 women on duty for night shift in below ground mines, because mines are of different open cast, below ground. For that also, whether women will be employed or not, for that very specific guidelines have been given. Then a separate well-lit and ventilated toilets and urinals for female employees, separate locker facilities, all these welfare, very minor details have been thought of and given in the labor codes. Next. Proportional welfare, as I said, in various committees there has to be proportional representation of women workers. Next. These were all in a nutshell, as I said, sir. I am sorry I exceeded my time limit, but it was required to ensure that the philosophy behind the labor codes are actually communicated to the audience. So thank you so much for this opportunity. Thank you so much.